You finally have a promising invention. So you do what most new inventors and founders do. You post a teaser online. And by the time you realize something went wrong, it may already be expensive or impossible to fix. Let's walk through 5 patent mistakes that can seriously damage your rights. Note first, this is educational information, not legal advice for your specific situation. But if you're an inventor or founder, these are the mistakes you want to catch early. Mistake number 1, public disclosure before you understand the rules. This is one of the most common inventor mistakes because it feels completely harmless. You're excited, you want feedback, you want validation. So you post a video, you publish a landing page, you show the invention at an event. The danger is the patent system cares a lot about timing. And the painful part is that new inventors usually don't think of a social media post as a legal event. But from a patent perspective, that post may reveal the invention to the public. The safer alternative is simple. Before you publicly show how the invention works, pause and document what you have. Consider a patent search. Talk to a patent professional before you make the details public. Mistake number 2, unclear ownership. This one is especially dangerous for founders. A lot of inventions are not created by one person sitting alone in a room. Maybe a friend helped with the prototype. Maybe a contractor designed part of the product. Maybe a co-founder drafted the technical drawings. The mistake is assuming that because it was your idea, that you automatically own everything. That may not be true. Patent rights can depend on who actually contributed to the invention. Business ownership can depend on contracts, prototype files, CAD drawings, software, branding, and technical improvements that have separate ownership issues. New inventors make this mistake because they're moving fast. They think casual collaboration will be treated informally because the product isn't real yet. The safer alternative is to get ownership clear before people contribute. Mistake number 3, premature pitching. This is a classic founder trap. You believe the invention has potential, so you start pitching. And because you want them to take you seriously, you explain the important parts, the mechanism, the features, the design, the advantage, the thing that makes it different. That's where the risk begins. Pitching can create patent problems if you disclose too much before you have protection or before you have the right confidentiality structure in place. Have a non-confidential version that explains the opportunity without giving away the invention's most important details. Mistake number 4, filing a weak provisional patent application. A provisional patent application can be useful, but a weak provisional can just create a false sense of security. That happens when inventors file something too thin, too vague, or too rushed. If the provisional doesn't adequately describe the invention, it may not support the claims you later want in a non-provisional application. That could become a serious problem when deadlines arrive or when competitors appear. The safer alternative is to treat the provisional like the foundation of a house. Mistake number 5, relying on ChatGPT for legal conclusions. This one's becoming more common. An inventor asks ChatGPT, "Can I patent this?" Or, "Did I already lose my rights?" Or, "Is my invention obvious?" And the answer you get sounds confident, like it knows what it's talking about. But the answer you get is not always as correct as it is confident. The safer alternative is to use ChatGPT for preparation, not legal conclusions. Ask it to help you list facts to gather. Ask it to help you prepare questions for a patent attorney. Ask it to help summarize your invention in plain English. But before you make a high-stakes decision, get qualified advice. So here's the safer checklist before sharing your invention. First, write down what the invention is. Second, document timing. Third, identify everyone involved. Fourth, control disclosure. Fifth, consider a patent search. Sixth, consider a provisional filing if you need to move quickly. Seventh, get attorney advice when the stakes are high. The big takeaway is this. The mistake is not being excited. The mistake is not talking about your invention. The mistake is not using AI. The mistake is moving in the wrong order. For inventors and founders, the order matters. Before you pitch, before you use ChatGPT, understand that it can help you prepare, but it shouldn't replace legal review. Before you take any steps to protect your idea, you really need to find out whether you have an innovation and that you understand what really makes it unique so that it can be properly portrayed to the US Patent Office. Book a strategy consultation with Goldstein Intellectual Property today and get clarity on the smartest next step for understanding whether you have a patentable invention.